very famous case, due to their lack of resources, because in effect this privatization of reproduction limits people's access to it. Equally in India, we saw very restrictive, or we saw progressive policies allowing contraception and access to contraception, which was then manipulated by governments who were concerned about population growth, where forced sterilization occurred, or people were put on long-term contraceptions, which actually they were unaware of the consequences of being on these. So context is key, and we have to sort of examine the choices and the context around these choices that people are autonomously making. Failure to recognise the structural inequalities and constraints on women's reproduction in turn leads to reproductive injustice, and which impedes them from when they are not fully understood or integrated into future policy and law reform. So the Hague Conference on Private International Law have been tasked with drawing up a convention on transnational surrogacy arrangements, and hopefully that will be soon, although very unlikely. But again, they focus on the best interests of the child concept and narrow it down to informed consent. I believe this is limiting, a limited view of looking at this topic. Reproductive justice requires a positive obligation on the part of the state. Unlike privacy, which is largely a negative right, this positive right would necessitate state intervention. Some people might call that paternalistic, and there is an argument for that, but this state regulation is a way of protecting people from the market that very often favours whiter, richer people. So, the framework. So my framework actually presupposes altruism. So John has dealt very well with the altruistic commercial divide, and it is a huge area and one that I will not be entering into, but to recognise that just latent economic forces do have an impact on who are compelled to enter these markets or induced by financial incentives to enter these markets. Although European consensus is hard to find, Belgium, the Netherlands, the UK, countries that are regulating surrogacy in the European context are doing so on an altruistic basis. Now, the exact euro that defines altruism and commercial is as yet undecided. But this model recognises the unique and special nature of these contracts, given the fundamental rights that are involved, both with the gestational surrogate and the children that are result from these agreements. I propose that Ireland adopt an independent authority or a monitoring body that would be tasked with bringing together the intended parents and the gestational mother or a surrogate in a means that their asymmetry of power can actually be equalised. So this is very similar to like what John was mentioning earlier. They would have separate legal representation. This body would also be responsible for psychological screening of intended parents and the gestational mother. And I know that there is resistance to regulate in this area and make judgment calls on who are fit to be intended parents or gestational mothers, but we do this all the time. When we have an opportunity to do what would be in the best interests of the child, we are legally compelled to do so for future children as well. So this monitoring body would also mediate. So it would be almost like the family mediation service, where the two parties can work out the terms of the contract and be represented in that. There is a double protection in the model that I propose, that once the contract has been drawn up by this authority and the parties involved, that it would then be sent for judicial supervision. At that time, the judge can make an order of court, and then fertility treatment can proceed after that. There is always an argument that, well, you can't stop people doing this, but the fertility industry are made up of medical practitioners who rely on medical licenses. We can stop fertility clinics from acting in this way or punish people when they circumvent the law in Ireland, at least not internationally. I believe that intended parents and the gestational mother need to have access to all records of the other party oftentimes when people are drawing up contracts, the intended parents have full access to the gestational mother's records, but this never goes the other way around, and I believe that we just need to be fair from the outset. Provisions must respect the bodily autonomy of the surrogate. They cannot be compelled to have medical treatment or a particular type of birth. If you look at general, and you can Google surrogacy contracts and millions of different types come up, there will be provisions in that the gestational mother must give birth in X hospital, that they must have a cesarean section. I believe that these are too constraining. Although they are an important factor in the considerations of the contract, these cannot be legally enforced on the gestational mother. There is thus a distinction between provisions of the contract that are legally enforceable during pregnancy and those that are applicable upon the birth. Upon the birth of the child, the intended parents become automatically the legal parents of that child. But to say that they are the legal parents before a child is even born, I think is unrealistic, it's unpractical, it contravenes the surrogate's rights to bodily autonomy too much. That doesn't mean that they are not discussed in the contract, and you would hope that there is a meeting of the minds, but in any practical sense, women could not be stopped from having a termination. Well, in Ireland they could. They couldn't be stopped from leaving the jurisdiction if they wanted to. I mean, don't think I could see a place where courts would be injuncting women to stop them leaving the country because they are carrying a gestational child for somebody else. But you never know, stranger things have happened. So the gestational mother does retain the right to petition the court upon the birth of the child. This is a bit of a distinction. They do not acquire the parental rights. They cannot petition the court for parental rights, but they can petition the court for access to that child, access, guardianship, or custody, depending on the circumstances of each case. It may be in the child's best interest that the child actually does remain with the gestational mother, and I think it's very difficult to recognise that a gestational mother is an adequate provider of care and attention to gestate the child, and then completely sever that right upon the birth of the child. This does not mean that courts will necessarily grant access or guardianship or custody, but it will give the gestational mother at least the locus standi to petition the court. I do believe there should be a genetic link between at least one of the intended parents. The double donor model, they have no genetic link to that child. Nobody has. So it would beg the question, why don't they adopt? And I know there's a lot of issues with adoption as well, but it seems unusual. You know, I won't go on too much about that. As I work through the other domestic responses, I will be drawing back to certain elements of this model, and I welcome questions as well, because it's not completely worked out yet, but that is the bones of what I would be presenting. So the Supreme Court, as noted earlier, has been very, very restrained in Ireland, and they have left it to the legislature to enact laws in this area. It is so complex, and I do think it was right, their decision in that regard. Other courts have not been so restrained. In the US, we have seen very specific judicial activism, although back in 1993, in the very famous case of Johnson v. Calvert, where Anna Johnson was contracted by Mark and Crispina to gestate a child that she was not genetically related to. Therefore, it was a case of full gestational surrogacy. The court were very adamant that it was the genetic link and the intention. They stressed the intention, though, of the intended parents that gave rise to the parental relationship and responsibilities. This has been followed subsequently in most court decisions from California. In the Buzankia case in 1998, this was a double donor, so no genetic link to either the intended mother or the father or the gestational mother, and the couple separated in that case, and the intended father, tried to abdicate his responsibilities to that child. The court firmly held that no, it was his intention to bring about the child. He is therefore responsible for that child forever. In JF and DB in Ohio, the court there held that the surrogate had no rights to forego, so that they are not deemed to be the parent at any stage of this process. Therefore, it didn't contravene public policy because they had no rights to begin with. In Minnesota, again, they actually use contract law principles and language. The California court are slow, or they don't really like using contract law language, and they don't speak to the validity of the contract, although they implicitly enforce all the provisions of that contract. So in Minnesota, in PGM, they said when a surrogate knowingly and willingly enters into such an agreement, there is no reason that they could find that they shouldn't be held like any other contract to the provisions set forth in it. They are all traditional, or not traditional, they are all commercial surrogate, or they are all full surrogacy arrangements, so no genetic link to the gestational mother. So it's clear that they never have parental rights in the eyes of the court. What is less clear is in the case of traditional surrogacy arrangements, where the gestational mother uses her own egg and is fertilized by either donor sperm or usually the intended father's sperm. But the court have recently even they have sort of merged the distinction between traditional and full surrogacy because they hold that intention is so important in these arrangements, thus reducing the biological link between the gestational mother and the child. This has been the case in the FTR case in Wisconsin. It has also been the case in the ALS in Minnesota, where the trial judge in that case, sorry, I didn't look on it all. To know where I am. Domestic, yeah, we're still good. Where the trial court in that case, they effectively compared the gestational mother to nothing more than an egg donor, even given the fact that she gestated this child for 9 months, that the court didn't see any rights arising from that. So, India has been discussed as well. There are many issues within the Indian context. Since 2002, they have had legal surrogacy, although it's heavily unregulated. And even when India do enact guidelines, their adherence is very often not very, can't think of the word, not very well adhered to by the fertility clinics. And largely this because these are commercial enterprises that are making a lot of money from this, and lots of issues arise in the Indian context in particular. The countries that have adopted this ex-ante model, where they determine the parentage before a child has even been born, they have been alluded to earlier: Israel, South Africa, and Greece. And these do provide a very interesting model, which I do believe that Ireland should concentrate on. Greece have relaxed their residency requirement recently. So given the Schengen agreement, I mean, Greece is likely to become a very popular destination country for Europeans who want to access surrogacy arrangements. The courts pre-approved the surrogacy contracts in that, but what they are relying on is affidavits. So whether this is robust enough, whether the court can actually inquire as to the consent and the knowledge of all the parties involved, is at least questionable. South Africa as well. Very often the court stressed in South Africa the inequality within their society and the need for strict judicial supervision of surrogacy contracts. But as time has gone by, the court has, in ex parte WH, they have laid down what is meant by reasonable expenses, and they've sort of put meat on the bones of the legislation. But then in a subsequent case, ex parte MS, the court declared or granted a declaration of parentage not before implantation and fertilization, but before the birth. So they have already started pushing the boundaries of when they will grant parental orders. Again, this is because of the best interest of the child are held to be paramount. So it undermines all the laws. I'm not saying it's a right thing or a wrong thing, but adherence to these strict principles are very difficult and challenging. Israel is a very interesting case. They have had they were the first country to regulate surrogacy. So back as far as 1996, Israel have an approvals committee. So similar to what I would advocate for Ireland, but in that model, commercial surrogacy is actually legal. So the approvals committee, it just has to be transparent. Israel is restricted to heterosexual couples, so is Greece to become intended parents. Surrogates in Israel are limited to unmarried women. So I think these laws tell you an awful lot about the country and the sort of the impetus behind these laws and the hidden messages of how are women valued, what type of women are valued in these societies. For Ireland, I would suggest that we have a hybrid of the Greek model, the Israeli model, and the South African model, with this awareness of the inherent inequality in surrogacy contracts. That it be non-discriminatory, obviously, that heterosexual couples, homosexual couples, the research from Gollenbach is amazing on this, that there is no justification to exclude anybody based on their sexuality from the research that is being carried out. Whether single people should become intended parents or have the right to at least apply to be single parents, I think should be determined on a case-by-case basis by the approvals committee. We cannot just segregate out a whole class of people without actually assessing maybe they would be adequate parents in this scenario. The definition, because my model separates out upon birth, pre-birth and post-birth the parental rights, it fits with the Roche constitutional definition of what is a mother. A mother can only ever be not only ever be, but it is the woman who is pregnant. So it will pass the constitutional test on that way. There are many challenges going forward, huge amounts of challenges, but that doesn't mean that there is a reason that Ireland shouldn't regulate and encourage people to stay in Ireland for safe, legal, regulated, altruistic surrogacy arrangements.